There are 84 of them, so it'll take a while.
Oh, no thanks.
Yeah,
No?
yeah, I'm fine with those being digital.
All right.
Yeah, I don't think this file can handle another 84 pages.
Here is
That's
the
stretching.
initial copy, I think. Did you need his initials on there, on this, right?
Page 3, or page 4, actually. There we go.
Yeah.
Yep.
Is that good?
And then, yep, perfect. That looks good. If that can be submitted as the attachment,
Yeah.
that's good.
All right. Is that? Oh, I meant Ethan.
Okay.
Those are just the restitution
It's the same
orders. Yeah, it's the same. It's going to be the same numbers.
Yeah.
And then I've got the plea petition and the attachments here.
Perfect.
Do you think you expect more restitution coming in? Do you expect
Are you
more?
expecting more?
I don't expect any more.
But you want to keep it open?
Oh, did you?
Yeah.
Okay.
Maybe not.
It'll be kept open for 90 days past entry of judgment.
Okay. I wonder if we could enter an order now and
Okay.
You good?
Yeah.
Get the judgment in sooner.
then. Yeah.
Yeah, I mean, usually it only takes a week or two. Can sometimes be longer or shorter, but that's what the statute says.
Okay.
How easy is it to facilitate?
That's a copy.
Where?
I printed one, yeah.
It's easy.
Or actually, if you had other things.
That's
His initials on it.
Okay.
we can make it happen.
No, I did not. Okay. Sounds
I
good.
mean, I made sure that this amount was in the account.
Let me just look and see if that's the same as the.
They're less serious about it. Just don't. If it rings, that's bad.
All right, I will follow.
Yeah.
Hello, this is KL Morgan on video. I just wanted to let the clerk know that I am available if anyone needs the ASL interpreter. Thank you.
Hi. All right. Thanks. All right, counsel, should I let the judge know we're ready?
Sure.
She might have different standings.
Thanks for sharing.
All rise. Multnomah County Circuit Court is now in session. The Honorable Cheryl Albright presiding.
Good afternoon. Please be seated. And we are on the record.
Good afternoon, Your Honor. Eric Pickard for the state, PICKARD, bar number 154015. We're here in the matter of State of Oregon v. Joseph David Emerson, court case number 23 CR 51764 for a change of plea.
Good afternoon, Your Honor. Noah Horst, HORST 076089, with my colleagues, Mr. Levy and Ms. Van Duzen, on behalf of Joseph Emerson, who is prepared to change his plea pursuant to a plea agreement to one of no contest.
Okay, and I wanted to let counsel know that when I take the no contest plea, I'll be asking for a factual recitation from the state and whether there's a stipulation from the defense. And whoever needs the ASL interpreter, are you able to see the interpreter? Just checking.
I am not able to see, the interpreter is unable to see who I'm interpreting for, Your Honor.
Yeah, I'm not sure who is in need of that.
Right there.
Can you identify yourself for the record?
Absolutely, Your Honor. KLKAYELLE Morgan, oath on file, legally certified.
Okay, thank you, Ms. Morgan.
You're welcome.
Yeah, so I'll go ahead and get started. So Mr. Emerson, I'm looking at a plea petition that tells me that instead of going to trial in your case, you would like to plead no contest to count 1, endangering an aircraft in the first degree, and counts 2 through 84, recklessly endangering another person. Is that your understanding of what you're doing?
Yes,
And is that your signature on the petition?
yes,
And did you understand everything that you reviewed in the paperwork with your attorneys?
yes,
Are you satisfied with the assistance that you've received from your attorneys?
yes,
Have you had enough time and information to make your decision, and is this the way that you want to deal with your case?
yes,
Are you feeling clear-headed, like you understand everything and making good decisions for yourself?
yes, I am.
I will review with you the rights that you have to fight these charges at trial. There are the rights that you're giving up when you enter a plea instead of going to trial. They're the same ones that you reviewed in the petition with your attorney, and I'll just go over those again with you for the record. So are you aware that when you enter a plea, you give up the right to make the district attorney bring all the witnesses, all the evidence to trial, and to prove these charges against you beyond a reasonable doubt?
Yes, I am.
And that you're giving up the right to have your attorney help you by presenting any defenses that might apply and making arguments to the jury they should find you not guilty.
Yes,
And that you're giving up the right to have a jury listen to the evidence, listen to arguments and defenses, and they would have to make a unanimous decision in order for you to be found guilty.
yes,
And you are also giving up the right to have your attorneys challenge evidence by filing any legal motions that might apply or making objections to evidence at trial. Did you understand that?
I do understand that.
And also, are you aware that you're giving up the right to have your attorney cross-examine and challenge witnesses who testify against you?
Yes,
If you wanted to bring witnesses of your own to court, you could do that by getting the judge to issue a subpoena to order those witnesses to court, but you're giving up that right. Is that your understanding?
I do understand.
You're also giving up the right to take the stand and testify and tell your side of the story in your own defense.
Yes, I understand.
If you did not want to testify, you don't have to, and the judge instructs the jury that they cannot use your silence as evidence against you. So are you aware that you give up the right to have the judge give that instruction if you wanted to remain silent at trial?
I'm aware.
But since you're entering a plea today, you're giving up that right, and I can ask you questions about your case. The endangering in an aircraft in the first degree charge is a Class C felony that carries a maximum sentence of 5 years in custody and $125,000 in fines. And each of the recklessly endangering another person charges are Class A misdemeanors and carry a maximum sentence, each of 364 days in jail, and says here $5,000 in fines. Are you aware that's the maximum penalty that you face?
Yes, I am.
And are you aware that if you are not a U.S. citizen, this plea could be used as grounds to deport you, deny your application for naturalization, or exclude you from future admission to the United States?
Yes, I'm aware.
And that if you were on post probation, parole, or post-prison supervision for anything, this could be used as grounds to violate your supervision, and you could get jail time in addition to any jail time that you face here.
Yes, I'm aware.
And you will be required to provide a blood or a buccal sample that will be kept on record for the state for DNA.
Okay, yes.
And I don't think there are any charges being dismissed, right?
Correct, Your Honor.
There is a joint agreement. You've entered into negotiations with the state, and that involves pleading or stipulating to a grid block of 8I, and this is the sentencing guidelines that apply in Oregon, and there's a presumptive prison sentence in the 8I grid block of 16 to 18 months. Did you understand that?
Yes.
And however, it's a stipulated downward departure from that presumptive sentence, from that presumptive prison sentence to 60 months formal probation. So did you understand that?
Yes.
When you're on probation, there are general probation conditions that apply to everybody, and it's by statute, and it includes paying any fines, fees, or restitution as ordered by the court. If ordered, submit to testing for controlled substance use, participate in a substance abuse evaluation and any treatment as directed, participate in any mental health evaluation and treatment as directed, remain in the state of Oregon until written permission to leave is granted. We'll be discussing a little bit of that later. Do not change residence without permission from your supervising officer. Permit the probation officer to visit your work or home to do a walkthrough. It is a condition to consent to the search of your person, vehicle, or premises upon the request of the supervising officer if there is reasonable grounds to believe that evidence of a violation will be found. Also, a condition to submit to fingerprinting or photographing if requested. Obey all laws, so any new criminal violation, but also traffic violation could be used as grounds for a probation violation, and you could get jail time in addition to any jail time that you face here. Promptly and truthfully answer all reasonable inquiries from the supervising officer. Do not possess weapons, firearms, or dangerous animals. Report as required and abide by the direction of your supervising officer, and if ordered, submit to a risk and needs assessment as directed by your supervising officer. Did you understand those general conditions?
Yes.
And there are some special conditions that include a jail sentence, 50 days of jail with credit for time served. Community service, 664 hours, which I understand to represent 8 hours for each of the passengers, and to be done at a minimum of 12 hours per month. Restitution, you're stipulating to causation and liability for restitution. Do these amounts reflect a final amount?
Your Honor, we're going to be asking to keep restitution open for 90 days past entry of judgment in the event another victim wishes to pursue restitution.
Okay. We can do that. In the meantime, the restitution that is already known is $59,608.25 to Alaska Air Group, $573 to Yvonne Millam, $387.88 to Anthony Wang. Did you understand those special conditions?
I do.
It's possible, potential that more restitution may be coming within the next 90 days. And if so, you are stipulating to causation and liability for that restitution in an amount to be ordered by the court. And you have a right to be present in court at any time the judge, the court signs a restitution order. You can talk to your attorney about, if that does happen, about whether you want to be present for that or whether you want to waive your presence for that. And if there is a restitution hearing, part of your plea agreement is that you agree to the admissibility of any written estimate from a business or victim as evidence of a damage amount, and that any witnesses can appear by video or telephone at a restitution hearing. And you are also agreeing that any money seized or bail posted can be applied to the restitution in this case. Did you understand all of those conditions?
I do.
Okay. Those are general conditions. There are some specific conditions that are checked off here that are already general conditions. It's also a condition that you not have any contact with any victims or witnesses in the police report, except any letter or statement of apology per your PO. You are stipulating to the relinquishment and forfeiture of any seized property that's listed as evidence. Is that applicable here, other than bail amount?
Your Honor, I don't actually think that that's going to apply to anything else. We haven't discussed anything except a cell phone, which I don't believe is in the custody of the Port of Portland Police Department. So other than that, I don't anticipate there being any property issues.
So you are also agreeing that the probation officer can impose and require any of the conditions that we already discussed, are the special conditions, and that there may be additional conditions, even if not specifically listed in the pretrial offer agreement of the parties. So condition that that the probation condition to obey all laws includes the requirement that you obey any court orders regarding probation conditions in other cases. So I don't believe this applies to you, but if you were on supervision in another jurisdiction and a judge ordered you to do something in that case, that would apply in this case as well. If you, the state, there or any future probation violation hearing, that you can appear by video or telephone. And probation will come back to me as the probation judge, any of those hearings. No entry into or within 25 feet of an operable airplane or multi-passenger aircraft without written PO approval. No use or possession of controlled substances except pursuant to a medical prescription, and comply with any and all supervisory orders as listed in United States versus Joseph David Emerson, case number 323 MJ 00185. Did you understand all of those special conditions?
I do.
If you fail to follow any one of that list of conditions, there can be a probation violation warrant. You can be arrested on that warrant, held in jail until a hearing, at which time a judge will decide whether you're in violation of your probation. So did you understand that's a consequence?
I do.
If you're revoked on the probation, well, first of all, at that other hearing, you can get additional jail time in addition to any time that you were already held pending the hearing. Did you understand that?
Yes.
If you are revoked on your probation, that is when you could be sentenced on count 1 to this 8I grid block, 16 to 18 months in prison with 3 years post-prison supervision. On the misdemeanors, you could be sentenced, if revoked, to the maximum sentence of 364 days in jail. And because of the number of victims, that could run consecutively. Did you understand that? Okay. When you plead no contest, you're not admitting that you're guilty, but you are acknowledging that if you did go to trial, a jury listening to the facts and applying the standard of proof beyond a reasonable doubt could enter a finding of guilty. So are you aware that even though you're pleading no contest, once you're found guilty, it's the same as if you'd pled guilty or been found guilty at trial?
I understand that.
Has anyone made any threats or promises to get you to enter pleas to these charges?
No.
How do you plead to count 1, endangering an aircraft in the first degree?
No contest.
And how do you plead in, I'm just going to say in all of the counts because they are each very similar. Of course, they're related to an individual person. But part of this plea agreement, I'm just going to ask, how do you plead to counts 2 through 84?
No contest.
Okay, and I'll hear a factual recitation from the state.
Thank you, Your Honor. On October 22nd, 2023, Joseph Emerson, an off-duty pilot, boarded Flight 2059 in Everett, Washington, bound for San Francisco. Emerson was deadheading and sitting in the cockpit's jump seat mid-flight when the aircraft was operating at an altitude around 30,000 feet. Mr. Emerson attempted to pull the red fire suppression handles in the overhead control panel. If activated, these handles would have shut down the hydraulics and the fuel to the engines and forced the aircraft to begin gliding. Fortunately, the pilot flying, First Officer Alan Koisel, and the pilot monitoring, Captain Emil Reamer, wrestled Emerson and prevented him from pulling the emergency handles all the way down. Mr. Emerson resisted at first, but eventually left the cockpit. Due to the quick reactions of the pilots, the lives of the 84 people on board, including Mr. Emerson, were saved. 11 of those people were under the age of 14. The flight was diverted to PDX. When Mr. Emerson was interviewed by law enforcement, he said he had not slept for 40 hours or so and admitted to having consumed magic mushrooms about 48 hours earlier. Mr. Emerson also admitted that he had been unwell before boarding the flight. A blood draw warrant was obtained and a sample of Mr. Emerson's blood was taken. After testing, the lab found no findings of toxicological significance. One note for the court to have a better understanding of this: one of the benefits that airline pilots have is being able to deadhead on flights, sit in a cockpit jump seat. But with that perk comes a responsibility. They have to be able and willing to take over to pilot in the event an emergency happens. This is something that all pilots know. It's something that Mr. Emerson knew. He was not well. He boarded that flight anyway and tried to pull on those levers.
Okay, and is there a stipulation that those facts submitted to a fact finder would support a finding of guilty?
Yes, Judge, we so stipulate.
Okay, I will accept the stipulation and also find that the facts stated into the record support a finding of guilty by a jury applying the standard of proof beyond a reasonable doubt. And we'll make a finding that Mr. Emerson has entered his plea knowingly, intelligently, and voluntarily. And we'll make a finding of guilty on each of the counts mentioned. Count 1, endangering an aircraft in the first degree, and each count of the recklessly endangering another person. And I understand you're ready to be sentenced today?
Yes.
Okay, anything additional from the state?
Yes, Your Honor. As we previously discussed, we have some victims in this case who I anticipated showing up via WebEx. I wasn't anticipating any victims showing up in person, but in the event that some have, I'd like to give them the opportunity to stand up, identify themselves, if they wish to make a statement. Doesn't appear there's anyone here in person. I'll do the same for any folks on WebEx. Any victims who wish to make a statement, please identify yourself and the judge will hear your statement.
This is the judge speaking. You can unmute and speak up if there is something that you would like to offer to the court at this time.
Hi, I would like to make a statement, please. My name is Allison Snyder.
Yes.
Thank you. My husband Stephen and I were passengers on Alaska's Flight 2059 on October 22nd in 2023. The choices that Joseph Emerson made that day and the policies that allowed them nearly led to our deaths. My husband and I are neither judge nor jury, but the consequences proposed today seem insufficient relative to Mr. Emerson's choices and actions, regardless of his explanations or circumstances. After a weekend of hallucinogen use and emotional tumult and years of untreated health issues, Mr. Emerson used his privilege as a pilot to board Flight 2059 and sit in the cockpit, the only seat available to him on a full flight. Mr. Emerson knew he was not fit to fly, a requirement for sitting in the cockpit. He knew his seat came with a duty to crew and to passengers, and he knew he was not capable of upholding those responsibilities. He just wanted to get home to his family, he has said. We all know what that's like, to need the comfort of home, to do anything to get there. But could he have made a better choice that day? Could he have found a flight with room in the cabin, taken a train, or even checked into a hotel to recover before flying? Absolutely. And yet he chose to go to the nearest airport, ignore his pilot's duty, and wield his privilege to sit in the cockpit of the next flight out, where he had the opportunity to do harm, endangering the lives of 82 others who also wanted to return to their families. Even after fleeing the cockpit, Mr. Emerson attempted to do further harm and open a rear cabin door. I believe that any passenger behaving this way would be placed on a no-fly list. Joseph Emerson's behavior that day showed he lacks the judgment to be a pilot and should never be allowed anywhere near a flight deck again. Like the choice made by Mr. Emerson that day, today's agreement is also a choice to make things safer for everyone who flies. You can send a strong message to all pilots that being fit for flight is a requirement with teeth, that lying and abusing privilege will not be tolerated and have lasting consequences. You can also choose to send a strong message that there must be better policies governing who is fit to sit in a cockpit instead of relying on a pilot's word and a captain's discretion. And importantly, you can choose to send a message that compels the FAA and the airline industry to fully support pilots who need and deserve mental health care by creating more effective policies and efficient systems that remove stigma and encourage pilots to seek treatment instead of penalizing them for admitting that they need help. Without industry change, we all know that this will happen again. It already has, with fatal consequences. My husband and I are lucky to be alive today, thanks to the actions of our incredible crew that day. They outnumbered Mr. Emerson and used their training and their wits to manage the unprecedented situation that night. But like each of us on that flight, they should never have been put in that situation. I have flown with more anxiety since that day, and I will continue to fly because I must, but I will never, ever feel as safe stepping onto an airplane. And no one should have to feel this way when solutions are within reach. So please make the right choice today. Choose to protect the millions of people who place themselves in the hands of pilots and the airlines every day. Please don't miss the opportunity to send a strong message that fuels real reform and does more to ensure the safety and the well-being of everyone who flies. Thank you.
Thank you, Ms. Snyder. Is anyone else on the WebEx who would like to speak up? Okay, I'll turn it over to you, Mr. Pickard.
Your Honor, I have a letter that was submitted from Christine Michelle Hackett, another victim in the case. She asked that I read this on her behalf. I am writing today as a former passenger of the October 22nd, 2023 Flight 2059 from Everett, Washington to San Francisco, which has resulted in Emerson. As a listed victim in this case, I understand that I have a right to make a statement at the sentencing hearing. Unfortunately, with rearrange my schedule to be physically present, but would genuinely appreciate having my statement entered into the record for consideration. I can unequivocally state that the events have forever changed my life. Going forward, I think to some degree I will always have trust issues associated with flying. For me, flying no longer offers a relaxing start to a vacation or holiday. Flying is simply a means to an end, which offers opportunities to work on life lessons of conquering fear and anxiety. I fly quite often and have found that I compensate for my personal insecurities by assessing the perceived condition of every member of the crew or flight attendants. While on the plane, I am always in a hyper state of vigilance, unable to rest, relax, or sleep. On October 22nd, 2023, I now view flying as an uncomfortable necessity, one that always poses some degree of personal challenge. I do not believe that anything positive can be achieved from incarcerating Mr. Emerson. I believe his actions were driven by his grief and mental health issues, further exacerbated by the influence of psychedelics. His previously served should be enough. The amount of financial restitution seems appropriate. The is reasonable. What I find concerning is the proposed amount of community service, 608 hours for each victim. It is true that no one was physically injured. The plane did not crash, and thankfully my experience losing both of their parents simultaneously. However, many individuals, myself included, were emotionally and psychologically impacted by this event. As a listed victim, when you see the impact to your life equivalized to 8 hours of community service, it really calls you to question the respective value of your life and experiences. What should be the value in hours associated with a lack of trust, anxiety, and having to emotionally revisit past events every time you step on a plane? I believe that numbers likely vary with each individual and their personal circumstances. Consequently, it is impossible to determine. Might I suggest that instead might we look at the potential outcome for Mr. Emerson's community service? Having worked as a former public school educator, I know firsthand the current mysticism, popularity of psychedelics, most notably mushrooms, amongst our children and young adults. I would urge the court to please consider ordering Mr. Emerson to meet his community service requirement by visiting 83 public schools to speak on the dangers and risks associated with the use of psychedelics, most notably mushrooms. Perhaps the scope of influence would be profound and would equate more with reaching a fair and equitable restitution for all parties involved. Thank you for your time and consideration. Sincerely, Christine M. Hackett.
Thank you. Any other letters or?
No, Your Honor. The state would ask that the court follow the joint recommendation of the parties. Your Honor has covered most of the broad strokes of the agreement already. I'll note a couple things. One, I believe when you were talking about the condition of the PTO regarding future PV hearings that the defendant could appear telephonically, that actually is limited to witnesses for the parties.
Oh,
I don't
there's
believe
a,
that's.
I thought there was a notice. Let me double check that.
I don't anticipate this would happen, but in the event.
Oh, you're right. It's witnesses and defendant.
Correct.
So I'm going to withdraw that. The condition is for future probation violation hearings, parties agree that witnesses for both the state and the defendant can appear by video or telephone. Thank you.
And I'd also like to amend one portion of the PTO regarding contact with victims. Instead of accept letter of apology per PO, I would just have that say accept per PO. I know there are some victims that are hoping to meet with Mr. Emerson in person at some point. I wouldn't want a condition of probation to be a hindrance to that.
Okay, I can amend it to that.
Thank you, Your Honor.
Okay, Mr. Horst.
Thank you, Judge. You've received the materials that we submitted and the letter that we submitted with them, so I won't repeat anything there, other than to just highlight the immense support that Mr. Emerson has, both personally and professionally. Recovery. I want to say also that Mr. Emerson is a remarkable human being. I've never met somebody like him before. His or the decision that he made to get on that flight in the condition that he was in has been authentic and remarkable. As I think you're aware, he started a nonprofit called Clear Skies Ahead to draw attention to the issue of pilot mental health, and he's been working tirelessly to travel the country by bus, by personal car, not by plane, in order to speak. Along that line, I'd like to just ask permission and for Mr. Emerson to travel to the HIMSS conference, or the HIMSS Recovery Conference, which is in Denver from September 13th to September 18th. HIMSS is a pilot-specific recovery program that would like to participate in. He has approval from the federal probation department.
Okay, you said Denver, right?
Yes, Judge.
Okay.
The other thing I want to make sure that we address, and I think Mr. Emerson would like to say a few things too, he does live in California. I believe that it's contemplated by the offer that he be allowed to remain in California. He's going to certainly need to go through the interstate compact to get that final permission, but as that is pending, I would like the court to give him permission to reside in California with his family.
Okay. Mr. Emerson, what would you like to say?
Thank you, Your Honor. First, I want to say thank you to Christine, Stephen, and Allison for your words. They deeply impact me. I have learned in recovery that I have to be willing to go to any length to remain sober. And that is part of this process. I plead no contest because even though anybody, I still made the decision to take psilocybin, and that led to my inability to determine that I was operating in reality for an extended period of time. That doesn't make this right. What happened was wrong and should not have happened, and I bear the responsibility for that. Your words, Allison and Stephen through Allison and Christine, will help me continue to live my life one day at a time, trying to progress and become better. I regret the harm that I caused. I regret the harm I caused to every single person on board that airplane, crew members and guests. I regret the harm I caused to society, which is part of what this process is about. This has affected people who were not on that airplane. I regret the harm I caused to my profession, the thing I gave my life to, and to those professional crew members each and every day who do fantastic work, especially to the two pilots up front who removed my hands and asked me to leave the flight deck, which I did. I am forever grateful to them and grateful to every guest on that airplane for listening to the instructions of the two flight attendant crew members in the back, because they saved my life. This difficult journey has made me a better father, a better husband, a better member of my community. And I lost external perspectives, everything I had ever worked for. But it's the greatest gift that I ever got. Because today I get to be the dad I was incapable of when I had to use alcohol to deal with life as life is. Today I intend not to use alcohol to deal with life as life is. And I'm grateful for that. I thank you for your time, allowing me to address the court. I am more than happy to speak to as many schools as possible for the rest of my life. I will speak to pilots who suffer in silence. I will speak to people who think, as I did on October the 20th, that I had everything under control. But I was incapable of grasping that I needed help. I'm glad I have had the help today as a result of my actions. Thank you.
I'd like to hear a little bit more about the nonprofit that you started.
Sure. Clear Skies Ahead is a nonprofit committed to creating a culture of wellness within aviation, both physical and mental health. The first time I saw my wife after being detained and in custody, through glass. She had spoken to some media and had talked about what her experience was of me prior to this incident. And she said, "I feel called to help." And I had never heard her talk like that. And it touched me deeply, and I said, I would like to help as well. Upon my release, pre-trial, as I was entering inpatient treatment for alcohol, I had a conference call with a friend of mine who started a nonprofit, and he helped sponsor and develop and grow. He brought his executive director on board.
Is
Our
that
main-
I think I read that letter, maybe.
I haven't. I want to see the rest that came out of the NTSB. I'm gonna forget. I don't have the right term for it. I would like to see all of the recommendations implemented. In the report to the FAA, it was stated that all of the recommendations are interconnected and all need to be implemented. And I applaud their efforts and hope to continue to see more efforts in aeromedical certification of aviators. They can make all the changes they want. Until we change as a culture, it won't matter. And that is why we exist. We exist because one of the statements in that ARC, Aviation Rulemaking Committee document, stated that a culture of wellness will take many different organizations with strong effort to move the needle. Aviators should get the care that they need because they are more than just aviators. They are worth so much more than just pilots. I will likely never pilot an airplane again. And I am okay. I am so much better today standing before you than I've ever been. That my life will slowly, and Christina and the rest of the passengers to forgive me.
Thank you. You may be seated. I will go along with the recommendation. I did review the materials submitted by the defense, including the binder of letters, and would you like those to be made part of the court record? You can let us know later, but
Thank you.
yeah. I want to acknowledge Ms. Snyder's powerful statement and the letter writer whose name what is her name again?
Ms. Hackett.
Ms. Hackett. So I want to acknowledge just how powerful and impactful your statements are, and how they highlight the critical importance of safety and scrutiny at every level. I understand the FAA has made some changes, but as Mr. Emerson has pointed out, there remains work to do. Pilots, surgeons, judges, police officers, they're among the people in our lives who we willingly give them our lives because we trust them. And I trust that you truly regret the act, and it does appear that you have worked assiduously to bring light to the difficulties that pilots face by having to always be that person that can never be fallible. But we all are, as we know. And so strengthening those resources and supports that are available so that we can earn that trust and fulfill it, because it's a solemn duty of people who are in that position. So this is definitely regrettable that we're here. I can only imagine all of the terror that all of the passengers felt and continue to feel every time they step through that door in the jetway. So, but I do support this recommendation, and we'll go along with it. And on count one, this is a sentencing grid block 8I. That grid block is by stipulation. The DNA blood draw does apply. This is a downward dispositional departure to probation, and it's an upward durational departure on the term of probation to 5 years. All of the general conditions apply. All of the special conditions that I read into the record apply. I'm not going to restate each and every one of them, but I will. Our judgment forms, of course, have lots of tiny language, so I'll leave it to you to make sure that you review the judgment. If there's anything that you believe that we've missed in our written form, please let us know. But our intent is for the judgment to capture all of that in the judgment form. And we can attach the plea offer, but we can't necessarily incorporate it as a judgment. So the 6 months form of probation. That's going to be 50 days of jail. And that is going to be, I understand he has served that time. And so we'll note on the judgment that it is time served. I do recall that he served a significant period of time in custody. So the restitution is going to be on this count?
The restitution for Alaska Air Group can be associated with count 1, and the others can be with count 3 and 4.
Okay. So for count 1, the restitution will be $59,608.25, and I'm signing that restitution judgment. And did you want the 664 hours on this count? Or rather, should it be on each count? How did you want that tabulated?
Actually, the PTO contemplated that would be attached to count 2 only.
Okay.
Because my reasoning for that, Judge, is that community service hours can equate to days in jail, and I wanted to reserve all time for all of the other counts.
Okay, got it. Okay, so I won't impose it on count 1. The restitution must be paid at a minimum of $1,000 per month, and I'm going to make Ms. Millam and Mr. Wang the primary restitution, and then Alaska after restitution to those individuals have been paid. But it should be at the rate of $1,000 per month. They should be paid within the first month. Leave restitution open, and by leaving it open, that leaves it open for all the counts. Would the parties agree to that?
That's fine. Thank you, Your Honor.
Okay. I think that takes care of those. On counts 2 is suspend imposition of sentence. That is going to be 5 years probation conditions to count 1. And let's see, Ms. Millam is is she count 2 or she count 3?
I believe that's count 3. The named victims for restitution I gave count 3 and then count 4.
Okay, 3 and 4. So will be 164 hours of community service, and that will be done at a rate of 12 hours per month. And I understand there's a negotiation regarding where half of those hours can be. Is that right?
Correct, Your Honor. The PTO contemplates that with the court's approval and then also with the probation officer's approval, that Mr. Emerson can complete up to half of those at his nonprofit. But
Clear sky.
the reason that language is there is because we expect he'll go through the interstate compact. He'll have somebody else watching over him more closely. They're going to be in a better position to determine a legitimate way for him to spend that community service time.
Okay. So 664 hours of community service attached to count 2. And that will be 332 of those hours may be done through Clear Skies Ahead. I think that the work in that program can go far to helping to rectify the harm caused. But that's going to be per PO because community service does need to be certain level of community service. So that's going to be per PO for the half amount. The rest of it can be done at a licensed nonprofit agency, another licensed nonprofit agency, also per PO. I'm going to note that, well, it's a count 1. I'm just going to go ahead and put that on count 1 that you have permission to travel to the conference in Denver, September 13th through 18th. And you've already noted that the interstate compact does apply. And so you'll need to check in with the probation department today on the 4th floor to get reporting instructions for the interstate compact. So count 2, I've already ordered the community service. We don't anticipate any, well, I'll waive any additional fees and assessments. So count 3 is going to be, so for each of the counts, 2 through 84, suspend imposition of sentence. All of the counts 3 through 84 are going to be concurrent conditions to count 1 and 2. Restitution to Yvonne Millam in the amount of $573. I'm signing that restitution judgment. Restitution to Anthony Wang in the amount of $387.88, and I'm signing that restitution judgment. Waive additional fines and any of the other counts. So that money can be devoted to restitution. I think that takes care of everything. I'll take a closer look at the judgment to make sure we got all of the details.
Thank you, Your Honor.
Thank you.
Thank you, Judge. Thank you.
Yeah, and then Mr. Horst, I know that you were talking about going to the 4th floor with your client to get those interstate compact reporting instructions. Okay. Okay, we can go off the record. The court's in recess, everybody. The only thing I'll be doing is signing all the paperwork.